Hold on a second.
Attorney Backley, APA Cole was here, but I believe you had stepped away, but she the offer she gave was a 12-month delayed sentence and amend the charge to attempted operation of a marijuana facility.
Is she not available anymore? Because last time we talked, she was going to dismiss his case.
Okay. Let me see if she's, no, she's not in the breakout room anymore. Let me see if I can get her to come back out, okay?
Thank you.
No problem.
Charles McCurry, unmute your microphone, state your full name, please.
Charles J. McCurry.
Morning, Mr. McCurry.
Good morning, sir.
Have ticket number 2275153991, the People versus Charles, CHARLES, McCurry, MCCURRIE. Mr. McCurry, you're charged with one count of allowing an unlicensed driver to operate a motor vehicle in the city of Detroit. Mr. McCurry, the people have offered that if you were to plead to that today, they would offer what is known as a delayed sentence, a 3-month delayed sentence. That simply means, sir, that you would be, if you pled guilty today, you'd be given a fine. Your fine would be $225. But in 3 months, if in fact you have not picked up any other charges and that fine is paid, this matter would be dismissed. It would not be on your record. Do you understand that, Mr. Murray? McCurry?
Yes, sir.
And how do you want to proceed today, sir?
I'll go ahead, sir, with the case in front of me.
You want to take this offer? Is that what you're saying, sir?
Yes, sir.
All right, Mr. McCurry, please raise your right hand and state your full name.
Charles J. McCurry.
Do you swear or affirm to tell the complete truth?
Yes, sir.
You may lower your hand. Mr. McCurry, do you understand that you have an absolute right, a constitutional right to have a trial? If you went to trial, the prosecution, the people, would have to present evidence. That could be testimony. It can be something physical. Well, it would most definitely be testimony. You would have the right to cross-examine any witnesses, and if there is any physical evidence, you would have the right to have that examined as well. The evidence as provided would have to rise to a level of proof beyond a reasonable doubt before a judge or a jury could find you guilty. Do you understand that, Mr. McCurry?
Yes, sir.
By pleading guilty, you give up your right to have a trial. Do you understand that, Mr. McCurry?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. McCurry, on the date of December the 14th, 2022, did you own a motor vehicle?
Yes, I do, sir. Yes, I did.
Did you allow someone to drive that motor vehicle who did not have a license?
Yes, sir.
Of that charge, sir, the court will give you a fine of $225. You have a delayed sentence of September the 6th of 2023. On that date, sir, I will go into the computer. I will look to see if that fine has been paid and if you've not picked up any other charges. If those two things are true, this matter will be dismissed at that time. It will not be on your record.
Okay.
If the money is not paid, sir, then I need you to come to court. Or if you picked
Yes,
up
sir.
other cases, then I need you to come to court.
Okay. You said September, one thing. You said September to make the payment?
September the 6th, sir.
Okay. Had a payment made,
dismissed.
correct?
Pardon me?
Had a payment paid in full?
Yes, sir. And
Okay,
make sure
then.
you have it paid. Make sure you don't pay it the night before, sir, because it's not going to show up in the computer that quickly. So I
Okay.
need you to have that paid at least 2 weeks before. That way it's going to show up in the system and I can just dismiss it on that date. All right.
Okay. If I pay before then, be okay, correct?
Pardon me?
If I pay before then, be all right, correct?
Yes, yes.
Okay then.
If you like I said, I'm just saying pay it at least 2 weeks before or pay it anytime earlier. And then I look out there, I'll see it's paid and I'll dismiss the matter. You do not have to come back unless you want to. You're welcome to come back to hear me say this matter is dismissed.
Okay.
But if you do not come back, we'll just dismiss it without you present.
Okay. Thank you, sir.
All right, good luck. You know how and where to pay, Mr. McCurry?
Yeah, I'll listen to you were saying like the kiosk in Parkway by me or the Thursday District Court. Y'all have a machine down there also. To pay it,
Sir.
sir.
Yes, the kiosk machine, the DivDat machines, you can pay there. So, all right, good luck
Okay.
to you, sir.
Thank
Mr.
you, sir.
McCurry,
Yes,
this
sir.
might make it a little bit easier for you. Do you know your case number?
Let me put my glasses back on. Yes, case number is 227-515-391.
Yep, that's it. That's it, sir. So you can, the other stuff, you don't have to worry about that. You can go in and pay by your case number, but it will find your name if you put your name in, okay, and date of birth. All right?
Okay, then, sir.
To you, sir.
Thank you, Your Honor.
You can sign off now.
Thank you.
Attorney Griffin, I believe that's all of your people for right now, right? You're muted. You're still muted.
Oh, sorry. Yes, I'm still working with Madam Prosecutor on a matter that's scheduled for trial.
Okay, all right, well, I guess we call Attorney Barrett some of her cases.
Okay.
Okay. I was trying to find Prosecutor Cole. I was trying to send her an email.
She's actually in room 17 right now, talking to Attorney Macklin, so
Do-
I don't know if you wanna hop in there real quick and then just ask her, can she go into a room with you when she's done in there?
Okay, so then I'll do that before you call the cases. Let me go down here so that
That's
you
fine.
catch. Okay.
Okay, Attorney Barrett, are you ready on Murphy, McKay?
Yeah, you can go here. But I'm still trying to work this out with Cole because she's working on the trial. But I go ahead and call the cases. I still gotta talk to her.
Question, did you have Sarah Martinez? Did you give her a trial date?
I did not have Sarah Martinez.
Okay, well then let me ask.
I did have Derek McMultry, and I gave him a pretrial of 629.
Okay, cool. Anybody else?
And then I had who's another one? And then that lady wasn't up to date, Michelle Maher, or however you say it.
Yep.
I
got her.
gave okay, 629 pretrial. Yeah, no, I didn't have her.
Okay. I'll ask Attorney when he comes back.
I'm gonna have to get Chris, Cynthia to look at this because. Yeah, Jekaiser McKay. I apologize if I'm mispronouncing your name.
That's
State your full name, sir.
Jakaiser McKay.
Okay, I did all right with it. All right, this is
Yes. How you
ticket
doing?
number P. I'm doing well, sir. Thank you. This is ticket number P1310845. The People versus Jekaiser, Jakaiser. McKay, McKay. Mr. McKay, you have 2 tickets. Both are misdemeanors. One is driving unregistered or untitled vehicle. The second one is no insurance. You were scheduled for trial today, sir. But apparently the officer indicates that he does not have any independent recollection of this matter. This is from this is from 2022, so it's December 2022, so it's 6 months old. In any event, the officer said he has no recollection. This matter is dismissed without prejudice. You can sign off, sir. Good luck to you.
Thank
You're all good to go.
you. Okay.
Damon Mock, unmute your microphone, state your full name, please.
Damon Jermaine Mock.
All right, Mr. Mock, you have ticket number P1418652, the People versus Damon, Damon, Mock, Mock. Mr. Mock, you're charged with drive while license not valid or improper. The people have indicated that if you were so inclined, they would amend and reduce this charge to fail to display. Fail to display is the lowest license charge there is. That's a charge that would suggest that you had a driver's license, even if that's not true. It's legal fiction. But they would give you the lower charge if you want to take advantage of that. How do you want to proceed with that? So you want to resolve this today with the reduced charge, or you want to set it for trial? Is this scheduled for trial right now? I don't know. It is scheduled for trial right now, sir. The officer is present, so we are ready to go if you choose to do so.
Judge,
Yes.
Melita Baird on behalf of Mr. Mock. I informed him the police officer was here and he wants to waive his right and plead guilty to that offer.
Very well. All right, Mr. Mock, I need you to raise your right hand, state your full name.
Damon Jermaine Mock.
Do you swear or affirm to tell the complete truth?
Yes.
You may lower your hand. Mr. Mock, you had the opportunity to speak with counsel. You understand that you have a constitutional right to go to trial, but if you plead guilty, you give up that right?
Yes.
Are you pleading guilty because you are guilty, sir?
Yes.
Mr. Mock, on the date of December 29th of 2022, were you driving a motor vehicle in the city of Detroit without a valid license?
Yes.
The court finds you guilty of the amended and reduced charge of fail to display a valid license. Your fine is $225. Can you pay that right away, or do you need time?
I need time.
How much time do you need, sir?
I could pay it Friday.
You can pay it Friday. Well, that's not really giving you time, sir. That's being prompt. I was just asking, do you need additional time, like 30 days, 60 days, 90 days, or something like that? So I'll tell you what, sir, why don't I just put down 30 days? You can pay it anytime within those 30 days, so you don't have to try to rush down here by Friday.
Okay.
All right. Now, if you want to pay it Friday, this doesn't mean pay it 30 days from now. This means pay on or before. So you always got the before out there. You can do that, sir.
Okay.
All right.
Okay.
All right, sir. Do you know how and where to pay, sir?
No.
Okay. You weren't listening to me, Mr. Mock, when I was telling everyone.
Yeah. At the kiosk.
Yes, that's one way. You can pay it online also, sir. The
Okay.
36th District Court website, but you can pay at the kiosk. You've probably seen them around, even if you didn't pay attention. Kind of looks like an ATM machine, but where people pay their utility bills. It's called
Yeah.
DivDat, DIVDAT.
Yes, I know what you're talking
Okay.
about.
All right, you can do it also there, sir. If you don't have your case number, let me give that to you. That just makes it easy to put your case number in when you pay the ticket.
I have it.
You have it?
SP1.
Okay. Yep.
SP1 4186-521.
That's correct.
Okay.
All right. Good luck to you, sir.
All right. Thanks.
Officer, you're all set. McCurry took a plea.
Did you say who? You said officer.
Yes, bringing some of the officers out to let
Right.
them know.
Officer Nichols.
Officer Nichols, yes, you're free to go. McCurry took a plea.
Okay, thank you. Have a good day.
You're welcome. You as well.
Be safe out there, Officer Nichols.
All right, Judge, you too.
I'm not out there, but I'll be safe anyways.
Yes, sir.
Okay. All right.
Reeves was here. No, we're about to. I don't have a file for
Nayla Murphy. Nayla Murphy, unmute your microphone, state your full name.
Nala Murphy.
Nala, I blew that. I had one chance, and I blew it. Okay, you have an attorney that comes in. There's an attorney that comes in this building sometimes, and you look so much like her. Could be your twin. So,
Wow.
so all right, Miss Murphy, you have ticket number P1419638. The People versus Nala, Nala Murphy, Murphy. Miss Murphy, you have 2 misdemeanor counts. Count 1 is driving unregistered or untitled vehicle. Count 2 is driving or operating a motor vehicle or having a motor vehicle parked on a city street. You do not have to be driving it if the vehicle is not registered or insured. It cannot be on a city street. They must be insured and registered on a city street, but they get caught more when people are driving. So in any event, ma'am, the officer who's on this case has come into court today and indicated that they don't have any independent recollection of that event. So they don't think that they can identify you. And apparently they didn't pull their video to refresh their recollection. So that all being said, it comes down to your case is dismissed, ma'am.
Okay, thank you, sir.
All right, have a good day.
You too.
Stay safe. You can sign off.
Thank you. Bye-bye.
Police Officer Goings. We handled the case for Mills, so you're free to go.
Okay, thank you, ma'am. Is that for Officer Vince Vogel as well?
Yes, I was trying to get him to come out, but he wasn't coming.
Okay, thank you, ma'am. You have a good day.
You as well, sir. All right. We only have a couple more people. I do not have the file for Mr. Mosee out here.
Yeah, I think Sydney still has it.
Okay, Ms. Mosee, they're still looking at yours for an offer. Just bear with us.
Judge,
Pardon me?
when I spoke to the city about Mr. Zabe, she said that the officer wasn't here.
Let me double check that.
No, Mr. Reed, she was mistaken. She thought he wasn't here, but Officer Reeves has been here since 8:30. He's in the breakout
Yes,
room.
he is here.
Okay, well, then Mr. Mozab needs to go back into breakout room, and I have to talk to her about that again because she was the one that told me the police officer wasn't here.
But counsel, that
Yeah, she took
we
the file
tell
back.
her. So
Yeah.
the officer is here, so she can't do anything about it. The officer is present. So
Yeah, she took the file back, so she still has it, but she's currently not in the courtroom, so you might have to email her.
you can talk to her about
Okay.
an offer, but it can't be dismissed because the officer is here, even if she thought the officer was not here. The officer has appeared. So and is present out there.
I understand. So I need to talk to her again. And then, yeah, I also have a couple of these people waiting for the state. So I got an email into Miss Cole, so I guess I'm waiting for them both.
Ms. Cole is out here on the screen right now in Zoom.
Okay, well, I sent her an email. Which room is she in now? Because she told me
She's not
that.
in a breakout room, but you can see her on screen. So I see her on the
She's in the main
telephone.
session. She's right here.
Yeah.
But it looks like
She's on the phone, so you can't, she muted her microphone. So when you see her hang up, then you can just speak to her.
Okay,
Do you
yeah.
see her?
No, hold on. Let me look at this. Oh, yeah, I see her. Miss Cole, can you hear me? I don't know if she got my emails. I sent her.
She's on the phone right now, so you can see that she's talking on phone. That looks like she just hung up.
Oh,
Attorney
I
Cole?
apologize. Yes.
Oh, not a problem. You got to take care of business. This is not the only courtroom that you have to deal with. So, all right. Miss Attorney Barrett is trying to speak to you about something. I don't know if you want to go, you two want to go into a breakout room.
I sent you an email.
Okay, I was looking for it. Hold on.
And then we have a resolution with Ms. Cole on Maddie as well, Your Honor.
Okay, well, we got a resolution. We'll call that right now, counsel.
Can you let, trying to let the officer know he can go.
I was just on the
Officer
phone.
for, hold on, Officer for Dante Mills, you're free to go. He, took a plea.
Okay, thank you.
You're welcome. Have a good one.
You as well.
Stay safe, Officer Vandervogel.
Thank you, sir. Take care.
You as well. Attorney Macklin, we can call your case now?
Yes.
All right, let's see. I'm looking for your guy. There he is. Mr. Matthew Matty, unmute your microphone, turn your camera on, and give us your name, please.
Yes, sir. My name is Matthew Donald Matty.
All right, Mr. Matty, you have ticket number 35757. Well, it's 22357576. The People versus Matthew, Matthew, Matty, Matti. You're charged with operation of a marijuana facility without a license. You are represented by counsel. Counsel, your appearance, please.
Morning, Judge. Amir Macklin representing Mr. Matthew Matti.
Very well. Attorney Macklin, you had an opportunity to speak with the city attorney. Is that correct?
Yes, Your Honor. I was speaking with Attorney Paula Cole. She's offered a delayed sentence.
I apologize. I said city attorney. You're speaking with the APA, assistant prosecuting attorney, who does state cases, Attorney Cole. All right, and you come up with a resolution. Is that correct?
Yes, Ms. Cole has offered us a delayed sentence for 90 days of an amended charge of a disorderly person.
Yes, and I just.
Oh, that's not what I have on. That's not what I have on the sheet that she faxed us. It says a delayed sentence of 12 months for attempt operation of medical marijuana facility. In the end, I guess it comes out to the same. But did you say 12 months, Attorney Macklin? The form she didn't.
3 months. 3 months, and it should be really only a day, Your Honor, but it's going to be 3 months.
Okay, I get that, but the counsel, Attorney Cole, that's different from what you sent me. I have 12 months with attempt.
She sent that before they went into the room.
So there's an amended plea recommendation form that I don't have.
Yeah,
that is correct.
Okay.
We had a chance, Attorney Macklin was kind enough to let us go into a breakout room with the Corporal John Talbert, who was part of the search space, and we agreed to amend it.
I have no problem with it. It's just what I have in front of me is just doesn't comport with what Attorney Macklin was saying. Now, I'm certainly not questioning Attorney Macklin's veracity because I've known him for a while and he is a beyond reproach. So
that was correct. I agree with that.
All right, so now that I am up to speed with what the two attorneys have talked about, let's do this. Attorney Macklin, can I bother your client?
Yes, Judge, yes.
Very well. Mr. Matty, I need you to raise your right hand and state your full name, sir.
Matthew Matty.
Do you swear or affirm to tell the complete truth?
Yes.
All right, you may lower your hand, sir. Mr. Matty, you're represented by Attorney Amir Macklin.
Yes, Your Honor.
And you've had the opportunity to consult with him concerning your rights?
Yes, Your Honor.
And you understand that you have a constitutional right to go to trial. You don't have to plead to anything. You understand that?
I do understand, Your Honor.
There's been a resolution that's been worked out with the state attorney, and you've been informed of that by your attorney. Is that correct?
Correct, Your Honor.
And you're pleading guilty to this charge with a reduced charge of, okay, I didn't write it down. The reduced charge was, what was the reduced charge, Attorney Macklin?
Disorderly conduct, Your Honor, that he was in.
Disorderly. Okay. So you're pleading guilty to a reduced charge of disorderly conduct, and you're going to have a 3-month delayed sentence. Is that correct?
Yes, Your Honor.
And you understand that delayed sentence is contingent and or dependent on you going 3 months without not picking up another charge and paying the fine that I'm going to give you today on it. Do you understand that?
Yes, Your Honor, I understand.
All right. The court has audited your client, and the court finds that Mr. Macklin understands he's been adequately advised of his rights by counsel, which I knew that would be the case. I just got to put it on the record. Adequately advised of his rights, and he understands his rights, and he's decided to take the reduced offer of disorderly conduct, and he have a delayed sentence of 3 months. Now, counsel, would you like to? We still got to make a factual basis, so yeah, I'll allow you to do that.
Your Honor, I just need the date and time in question of the.
The date is May the 25th of 2022. Location is Nottingham and Warren, but all we really need to say is it's in the city of Detroit.
On that date and that location, were you in the city of Detroit, Mr. Matty?
You were cutting off, I'm sorry.
On that specific date and location, were you in the city of Detroit?
Yes.
And did you come into contact with Detroit police officers?
Yes.
And did they demand that you walk out or remove from a specific location?
Yes.
And did you object to that demand and demand that you go back in to retrieve some of your tools?
No.
Were you not demanding to get your tools out of the building?
Well, they initially they wouldn't let us in. I did ask, and they
counsel, let me
push us away.
The factual basis has to be something that is more in tune to what the charges were, even though the charge has been reduced. Sir, was something illegal going on in that building that you were in, sir? Were they selling marijuana or growing marijuana in the building, sir?
I am not sure, Your Honor. I was just there to do an electrician job, and that was it. I don't know what was going on. We were in the back wiring. I was nowhere near the front until I had to pull wires.
Okay, well, counsel, this is not a factual basis. He's claiming innocence and not a plea. He can't plead to anything if that's what he's saying. So
right, he's correct in that, Judge. And I was talking more about disorderly person because when the police tried to arrest him,
but we can't make out a factual basis to what the reduced offer is. It's got a factual basis, and then the plea and the entry would be whatever the plea is, because so.
Well, he's never going to make that basis, Your Honor, because he can't make it. He's not guilty of that.
Well, no, but that's what I'm saying. If he's not guilty of it, we shouldn't even be doing a factual basis to get around something like that. We should. He should, if that's something that actually occurred and the people want to make an offer of something less, then we can do that. But if he's saying that nothing occurred, I certainly can't accept any plea.
Oh, I agree with you, Judge. I think that's the most appropriate thing. I was under the impression this case would be dismissed today, but Miss Cole indicated she wouldn't do it. I could proceed to a trial, Your Honor.
Okay. Actually, if
it's set for trial today.
It is set for trial, so we have the officer here. This should not be a long trial, sir.
I would offer we could do it as a NOLO plea if that would be like a no contest.
Yeah, I mean, at this point, Judge, I'd rather proceed to have some testimony. Attorney Cole, after what he said, I would not believe that we're doing justice by trying to get around something that he cannot say. If the NOLO plea is just giving, not because something didn't occur, but it's to avoid any ancillary type of penalties or something like that. But in this case, if he said he was just there as an electrician. I certainly would not even want anyone to plead, because I don't think that's doing justice at all.
Okay,
So,
so we'll have our trial.
I mean, you understand, Ms. Cole, that the other guy was dismissed because of that same reason. Are
I
you?
just like, that's not, has anything to do with this case.
That's fine. Okay,
well,
no problem.
I mean, if it could, obviously, if there's multiple people and they're all claiming the same thing, and that means that you might be aware that there might be a valid defense. So, all right, but we have the officer here. Do we have anything else, or can we just do this trial right now?
Attorney Barrett, what's going on with Mr. Moultrie?
Hold on one second. For Mr. Moultrie, he got his pre-trial date of June 29th. And then Kevin McCarthy got a trial date of June 29th. And then I was still waiting. I need to talk to the city attorney about Mozab since the cop's here.
Okay, yeah, I think she's still in the, I'll send her a text. She's still in Judge Williams' courtroom. They were having a sentencing hearing. For Moultrie, he's still in the breakout, so you might want to tell him the room.
Okay, excuse me. Moultrie is a plea, so let me tell him to come out. Okay.
Okay.
Oh, no. That's what it is with Mr. Moultrie. That's the thing. He is in the hallway because he's at the courthouse.
No.
And he tried to come in, so I
no,
told him.
We understand why he's here.
Yeah, he can't come into the courtroom, one, because I don't have an officer, and two, you're on Zoom, so it makes no sense for him to come into the courtroom. So what are we doing with it?
So can you pull him out of the breakout room so he can do his plea?
Oh, yeah.
So that's the only thing we have, and then we can do Mr. Macklett's trial.
Okay, there you go. Okay, he called in. Okay.
Well, Judge, I still have that Mozab I got to talk to the city attorney about.
Well, okay, but yeah, you can't do anything with that. It's a city come, so we can do Moultrie now, and then Attorney Griffin is still waiting to talk to city as well. So the last two people we have are waiting to talk to city.
And then we're gonna just go and do the trial. I don't anticipate this being a long trial. We got the police officer here ready to go. All right, Mr. Moultrie, let's see, what do we have?
Yes.
Hold on one second. Seeing how many tickets you have here.
And you said McCarthy is a trial, right? Attorney Barrett for.
Yes, on the 29th. He should be gone.
Okay. All right, thank you. Yeah, he is. I was just making sure.
Mr. Moultrie.
Yes.
State your full name, please.
I'm sorry, say it again.
State your full name, please.
Javon Moultrie.
All right, Mr. Moultrie, you have ticket number 19-40009. On this ticket, you have three counts. No operator's permit. Yeah, yes.
Moultrie, why are you standing in the courtroom?
Because I can barely hear him. No, you can't come into the courtroom, sir, because you have to.
Judge, I have one officer coming in.
Okay.
And I'm standing right here. I just want to get up.
I understand, sir, but we just can't have people standing in the hallway, and we have to have an officer in here if you come into the courtroom. So
I'll go see if I can get one officer.
all right, Mr. Moultrie is here. He came into the building because he said he did not have the ability to go onto Zoom. He has a cell phone, so he did a call in. He was working doing this in the hallway. He says he's having hearing difficulties, so we're gonna bring him in the courtroom, but we have to get a court officer first. Attorney Macklett. Yes.
I got an officer.
All right.
You can stand right there, or you can bring one to the table.
Yeah, you can sit right here at this table. All right,
Attorney Barrett, Mr. Moultrie is now in the courtroom. So,
Okay.
all right, Mr. Moultrie, I called the case. I'll do it again now that you're in the courtroom and you can hear me well. This is case number SP 9425113, the people versus Javon, Jayvon Moultrie, Moultrie. On this matter, sir, you're charged with no insurance. That's for a vehicle. You also have 91940000009. You have 3 counts on this ticket number. No operator's permit is count 1, unregistered motor vehicle is count 2, and no insurance is count 3. Those are all misdemeanors. You have SP 9425111, drive while license suspended. That's a misdemeanor. And lastly, you have SP 9425112, and that is driving unregistered or untitled vehicle. Let's see what we have here. There were some officers that were not present for his cases, correct?
No, Your Honor.
I don't think he's set for trial, Judge.
Oh, he's not set for trial. There's an offer that has been made that if you pled to one charge of 194000009, count 1, no operator's permit, they would amend and reduce that charge to fail to display. The other 5 charges would be dismissed.
Judge, he has a state charge, and Miss Cole.
That includes the state charge.
She said he had to plead to no registration.
Okay, Sydney, I thought Sydney had talked to her because Sydney wrote on here that the state charge was also being dismissed.
Okay. All right, well,
Ms. Cole, hold on 1 second. We got Ms. Cole right here. I'm gonna ask her. Ms. Cole.
Yes, I sent a second email. I'm sorry, Attorney.
So your charge is from 2000. Your charge, you said we're dismissing it?
Yes.
Yes, it's from 2018. So, okay,
Yeah.
we got that.
Okay.
Yeah,
All
so
right.
she got in touch with me later, and I'm sorry, I emailed you. You must not have seen it.
Okay.
So that means you would be Mr. Moultrie, you'd be pleading to 1 count. 6 would be dismissed. 5. 1, 2, 3, 4. 5 would be dismissed. 1 count of drive while license suspended, which would be amended and reduced to fail to display. Fail to display is the lowest license charge there is, or yes, the lowest license charge there is, because it's a charge that was suggested you had a driver's license, you just did not have it and show it to the police officer when you were stopped. You had an opportunity to speak with Attorney Barrett and discuss this, is that correct? Yes. And you want to take advantage of that? I need you to raise your right hand and state your full name. Ms. Barrett, Attorney Barrett, can you hear Mr. Moultrie?
Yes, I can.
All right, keep your voice strong, sir, because we're going through speakers. State your full name. Do you swear or affirm to tell the complete truth?
Yes.
You may lower your hand. You understand you have a right, a constitutional right to go to trial. If you went to trial, the prosecution would have to put on evidence. That evidence would have to rise to a level of proof beyond a reasonable doubt before a judge or a jury could find you guilty. Do you understand that?
Yes.
You understand by pleading guilty, you give up your right to go to trial. Is that, you have to speak?
Oh, yes.
Okay. And are you pleading guilty because you are in fact guilty?
Yes.
Mr. Moultrie, on that ticket number that we've discussed several times, 194000009, on the date of May the 2nd, 2019, were you driving a motor vehicle in the city of Detroit, more specifically in the area of Finco and Evergreen?
Yes.
Did you have contact with the police?
Yes.
Were you driving without a valid license at that time?
Honestly, I can't remember. It's 5 years ago.
All right, we go to trial. You don't, sir. You tell me that you don't know if you had a driver's license or not. So if I look in the system and it says you haven't had a driver's license in 10 years, you still will be saying, I don't know if I had a driver's license?
No, I had a driver's license in 2018, but I don't remember the circumstances. It was 5 years ago.
Well, this is 2019.
Well,
So, well, let me
Judge,
hold on. Let me put it another way. Sir, were you ever stopped by the police and the officer said you didn't have a driver's license and you had a driver's license? When he wrote you the ticket, he said you did not have a driver's license. He handed you the ticket. Did you say, wait a minute, I have a valid driver's license?
Sir, I'm honestly confused. I just want to pay my fine.
No, you can't pay your fine unless you're guilty, sir.
I'm guilty.
No, that's not the way it works. You're telling me you don't remember. What I'm saying to you, did you ever receive a ticket from any officer and the officer said, I'm writing you a ticket for no driver's license, and you said, wait a minute, I have a driver's license? So that's a very simple thing to say, because I would know if anybody ever gave me a ticket and I say, wait a minute, I have a driver's license. Why are you writing me a ticket for no driver's license?
Honestly, I was dealing with divorce. My mom died all at the same time.
Sir, you know what? Let me say this. We all have bad things and hard things in our life. We do. But I would know if an officer ever gave me a ticket and I had a driver's license. I would know that. I don't care if it was 50 years ago. I would know if somebody gave me a ticket saying I didn't have something if I know I had it. I mean, I don't have to remember the date and time, but I would know if somebody wrote me a ticket and I had a license, because I would be screaming bloody hell, murder. No, I got a ticket. Why are you? I got a driver's license. Why are you giving me a ticket for this? So, but
I would like to plead guilty.
well, Judge, today is not his trial day. So
I'm saying you cannot plead guilty if you don't think you were guilty.
I would like to plead guilty so I can move on with my life, Your Honor.
You're having a trial, sir. You're not hearing me. You cannot just say, I want to plead guilty so I can move on with my life. I cannot accept a plea of guilty if you are not guilty. I am sworn to do justice. I'm sworn to do what's right. I am not sworn to do what is convenient. And that's what you're asking me to do. Do what is convenient. I can't do that, sir. If you can't tell me you're guilty, I cannot accept it.
I just told you I'm guilty.
No, you didn't. You told me I want to plead guilty so I can move on with my life. You didn't say I'm guilty because I'm guilty.
I'm guilty because I'm guilty.
Ms. Barrett?
I told him that he has to be guilty and he can't just do it to move on with his life. I told him that, Judge. And if he can't remember, then he just has to have a trial date. Yeah. I don't know what else to say.
I don't know either, because this is a court of justice, sir, not a court of convenience. I have people come in all the time saying, well, I'm not guilty, but I just want to plead guilty so I can get it over with. So where does it stop? It's not a ticket anymore. Now it's rape charge or murder. It's like, and I'm homeless. I ain't got no place else to be, so I may as well go to jail. So I'll plead guilty. No, I can only accept a guilty plea if a person is guilty, sir. If you can't remember, then you can't, then you can't plead. You can't plead. You have to know that you did something that you can get a fine for or be punished for or go to prison for. You have to know that. You can't just say, well, I don't remember, but I just want to get this over with. And that's what people say all the time. And every single one of them, I say, you cannot plead, not before me. That's a court of convenience, which does not exist. Let's see. And that's Sydney's. Ms. Barrett, what are we going to do on this?
Well, Judge, I would say he gets a trial date, because if he's saying he's not guilty, because he either had a license or he didn't.
What you say?
I never said I wasn't guilty.
No, you said you can't remember, but that's the same thing. You can't plead guilty to something unless you know you are guilty. If you can't remember, you're not telling me you know you're guilty.
So I have a question.
Yes.
How would I defend myself if I took the trial if I don't remember?
But see, if you went to trial, there's someone else there saying what you did do. And this court has to balance what they believe.
The
So if
police
there's
would
an
show
officer
up.
saying, the officer is
police
there
officer.
saying, this is the person and this person wrote the ticket, and you're saying, I don't know, then I guess that's what the verdict is gonna be. But you can't do anything. I can't accept it if you're saying you don't know if you did something. I can't accept it. That's why I would have to have trial. I would have to have facts from someplace. And the facts would have to be rise to a level of proof beyond the officer could come in and say, I don't remember. And then that would be a dismissal or not guilty. I don't know what the officer is going to say. He may say the same thing. He might say, that was 2019. I don't remember. On the other hand, he could say, but I have a video of the event. And I remember because I refreshed my recollection. So whatever the facts are, I don't know what they're going to be. I have no idea. The officer hasn't talked to us. I don't know what he's going to say if he goes to trial. He could be just like you and say, I don't remember.
I believe that the officer was correct in his statement. And I feel like I'm guilty.
You know what, Madam Counsel?
Okay.
What we can do in this situation is he does not have to plead guilty. He can plead nolo. But I think you need to talk to him and explain to him what a nolo contendere play is, where you're just saying, you know, you understand.
Okay.
So
All right,
I can't listen to the attorney, so you have to go back out in the hallway. We'll put you in a breakout room. She can explain what a nolo contendere plea is. And then if she says that's good, then we'll come back and we'll finish this. So you're still on Zoom on your phone? Pardon me?
Yes. I was gonna ask, did he ever leave the breakout room?
Yeah.
Yeah, I hung up because my battery was low. I was on hold for an hour and a half.
Sir. So do you have any juice in your phone now?
A little bit. I don't know how long it's gonna last.
Okay, this should not take long. So if you go back out there, go back on Zoom, you'll talk to her. She'll explain a nolo contendere plea, and then we'll just come right back and finish it.
You want to do the trial for baby? Wait.
Yeah, I'm ready if you want, if the court's ready.
Okay.
Excuse me, before you get started.
Yes.
Do you all give people that opportunity to go to the driving school? Does this court do that?
This court doesn't do it, but the prosecutors certainly do.
Okay, well, I need to talk to Sydney. Is Sydney somewhere I can talk to her?
She's in room number 1 with Attorney Griffin. So I don't know if you want to hop in there and get your question in while she's with him.
Okay, thanks.
All right, Attorney Macklin, Attorney Cole, let's do this. This is, this is not expected. Yeah. What? All right, Mr. Matty is in the courtroom right now.
Yes, sir.
Ms. Cole is here. Mr. Macklin is here. This is case number 22357576, People versus Matthew Matty. We've already called this case a couple of times. He's charged with operation of a marijuana facility without a license. Appearances, please.
Hello, on behalf of the people.
Good morning again, Judge Amir Mackler representing Mr. Matthew Matty, who's present.
Very well. Okay, this was originally scheduled for a trial today, and I believe it was scheduled for a bench trial. Is that correct?
Yes.
Mr. Macklin? All
yes.
Right. So we're all parties are here ready to go. Mr. Matty, state your full name for the record, please.
Matthew Matty.
All right, thank you. Ms. Cole, we're going to have a trial today. Do you have any type of opening statement that you want to make?
Your Honor, just a very brief opening statement that at this point I have only Corporal John Talbert who will be testifying today how he encountered Mr. Matty in the area of 15500 East Warren on May 25th, 2022. And he was with a search crew and they had a search warrant. And at that time, they entered into the back room where they encountered Mr. Matty and several other people in an area where there was marijuana visible. And at that point, they wrote tickets out and gave tickets to several people at that vicinity for operating an illegal marijuana dispensary. And one of those people would be Mr. Maddie, who is here today. Mr. Maddie was dressed in civilian clothing. He was not seen. He did request afterwards that he needed to get tools out of the building. But it is the people's position that they would be able to show that Mr. Maddie was in an area where there was marijuana visible, and he should be found guilty of operating a marijuana facility without a license in the city of Detroit.
All right, Mr. Macklin, would you like to respond with a statement now, or would you like to reserve?
I'll reserve, Judge. Ready to proceed.
Well. All right. First witness.
That would be Officer or Corporal Talbert.
Yes, ma'am.
All right, Corporal Talbert, do you have a regular camera that you can show yourself and not just have a picture out there? Yes, that's what we need. So I need you to raise your right hand, state your full name. State your full name. Unmute your microphone, state your full name. You're muted.
John Eric Talbert.
Do you swear? Well, what is your, sir, leave your phone unmuted. Your position, sir, you muted it again. Leave it unmuted. Thank you. Leave it unmuted. And,
City of Detroit police officer. Been in the capacity 28 years.
All right, so you swore to tell the truth. You can put your hand down. All right, now you said you're City of Detroit police officer. Madam APA.
Thank you. And on May 25th, 2022, were you employed with the City of Detroit Police Department?
Yes, I was.
In what capacity?
Police officer, narcotics division.
And were you in the area, what were you doing in the area of 15500 East Warren?
Executing a narcotic search warrant for BC business. I can't remember the total name for a BC.
But you had a search warrant at that time?
Yes.
And did you gain entry into East Warren, onto that area?
Yes, I did.
How did you gain entry?
We gained entry to the front door of the location, which was unlocked at the time.
Who else was with you, if you can recall?
There was a whole crew with P.O. Levy, P.O. Krysak, P.O. Reno, P.O. Jackson, P.O. Williams. It was a good 10 or 15 of us.
And in executing the search warrant, did you come across Mr. Matty?
Yes, I did. In the rear of the location where the marijuana was being processed and sold.
Can you describe to me, when you say being processed and sold, what you meant by that?
It was being packaged in the back room area. And I guess that's where the customers would come out of sight of.
Sir, you can't guess and say, I guess. You can testify to what you know or what you saw or what you heard. Or you can't say what it appeared to be, but you can't guess about anything.
Once we entered into the back room, there was marijuana in plain view.
How much would you say?
Numerous edibles, numerous loose marijuana in jars and containers displayed for sale.
Now, did you see Mr. Matty how was he dressed?
He was dressed in regular civilian attire, maybe a t-shirt, blue jeans, maybe.
Did you see him? What did you see him doing?
He was standing there with his hands up, him and the rest of the subjects that were in the room. It was 3 more subjects.
Did you see him at any time touching any of the, when you came back into the room?
No, I
Touching
did.
the marijuana?
No, I did not.
Was anything confiscated from him?
No, there was not.
Was there any cash confiscated from that location?
Yes, $3,066.
At any time, were you able to determine if this was a legal marijuana facility?
No, they had, BC had instructed us that it was not illegal. That's why we were there with the search warrant.
When you say BC, what do you mean?
Building and safety inspection for the city of Detroit.
Were you able to determine who did own that building?
No, not at this time.
So your only contact with Mr. Maddie was that he was in the back room with several individuals where there was marijuana being packaged, you said?
Yes.
But you didn't actually see him packaging anything?
No, I did not.
Did he make any statements to you?
Once he was out, once the location was secured and processed, as we were securing the location, Mr. Maddie was outside waiting in a van, and he was requesting his tubes from inside the location. I explained it to him. I explained to him that I could not give him any property from inside of the location due to the fact that I didn't know if it belonged to him or not. If he claimed, if he was claiming ownership of the property, I could give him his tools back, but he refused to claim ownership of the property.
What do you mean by ownership of the property? The building itself or the tools?
The building itself. Because if he claimed ownership to the property and the building himself, for himself, anything inside the building was his. So I guess for that reason, since we found marijuana in the building, he declined from.
And I object to speculation. You know, he's speculating as to the mindset of my client as to that. But I mean, he could testify as to what Mr. Maddie said, that he certainly objected to not having ownership of the building. But to guess as to why he denied ownership of the building is speculation.
It's sustained, counsel. So that we'll strike that from the record.
Thank you, Your Honor. Now, Corporal Talbot, when your crew made entry, you said the door was open. Is that correct?
Yes, the business door was open. It was unlocked.
Was there anybody in the front of the building?
No, there wasn't.
So when you went to the back room, did you have to open a door, or how did you gain entry to the back room where the marijuana was?
Once you go past the counter, the sales counter, there was another separate back room that everyone was at.
How did you gain entry to that room?
That door was also open.
Did you make an announcement that the police were here with a search warrant?
Yes.
And then what happened?
Once we announced by saying Detroit Police search warrant, we entered the location, and after not seeing anyone in the front sales part of the store, we proceeded to the second door behind the counter, and that's where we found all the subjects.
And each of the subjects was given a ticket for operation of an illegal marijuana facility pursuant to MCL 333.27407(a), correct?
Yes.
Okay, I would pass the witness at this time, Your Honor.
Okay, thank you. Officer Talbot, now you're a narcotics officer for the city of Detroit. Is that correct?
Yes.
All right. And so, Corporal, now you've been trained through both your experience and through different police officer trainings about the sale of. Am I correct as to that?
Yes.
And in your training and experience, generally, when you're determining whether a person has been in operation of a drug house, a marijuana facility, or some form of a building, you would look for certain clues as to how that person was operating that facility. Am I correct?
Yes.
All right. And one of those clues is mail or proof of residency. Is that correct?
Yes, that would be.
All right. And you didn't have any documents that show that there's any proof of residency or mail to Mr. Maddie's name in that facility. Is that correct?
No, I did not.
All right. Another way would be to have a hand-to-hand exchange where an undercover officer or a confidential informant or some individual who was connected to the Detroit police would purchase some marijuana from Mr. Maddie if he was under investigation. Is that true?
Yes.
And that didn't happen in this case either. Is that correct?
No, it did not.
Another issue you would have is because B-Seed was the one that sent you guys in there to determine if this was an operating a marijuana facility, that you would be on the lookout for an individual based off of what B-Seed recommended to you guys. Is that correct?
No.
You weren't on the lookout for Mr. Maddie, were you?
No, we were not.
Okay. And B-Seed, which is the Building Safety Engineering Department, they didn't tell you to look for Mr. Maddie, did they?
No, they did not.
In fact, nobody knew who Mr. Maddie was when you arrived. Is that correct?
Correct.
All right. Now, ultimately, when you walked into the facility, you're in the rightful position of the search warrant execution. Is that correct?
Yes.
Rightful position is the first position to gain entry into the facility. Is that true?
I was second position.
Second position. Okay. But you're right behind the first position. Is that correct?
Correct.
All right. So the vantage point would be an immediate entry where you would see what the individuals were doing upon your coming into the space. Am I correct?
Yes.
And at that moment in time, as you gained entry and you canvassed the back room, you did not see Mr. Maddie, handling any marijuana. Am I correct?
No, I did not.
All right. And Mr. Maddie did not admit to handling any marijuana on that day. Is that true?
No, he did not.
Okay. And he didn't admit to operating a marijuana house. Is that true?
No, he did not.
Okay. Ultimately, when the building was secured and he was asked to walk and exit out of the property, he went into a utility van. Is that true?
Correct.
And the white utility van was a contractor type utility van. Am I correct?
Yes, it was.
Okay. And then in the conversation you did have with him, he was demanding that he get some of his tools back. Is that true?
Yes.
Okay. And at no point in time did he ever admit to having possession of marijuana. Is that correct?
No, he did not.
And when you told him that you had to have ownership of the building, he denied ownership of the building. Is that correct?
This is correct.
All right. You did not see him operating this marijuana house. Am I correct?
I seen him behind the counter where the marijuana was for display.
Very well. So merely present.
Correct.
All right. I have no other questions.
Just a little follow-up, Your Honor. When you say it was a contractor type van, did you see any writing on the van?
No, I did not.
Why do you describe it when you were questioned as a contractor type van?
It was a high top van with work gear in the back.
And did Mr. Matty ever tell you that I'm just here doing electrical work?
I believe he did say that at one point.
Now, you said that you saw him behind the counter where the marijuana was.
Yes.
Did you see what he was doing behind the counter?
He was just standing there with his hands up as we entered into the room.
Was anyone else behind the counter?
Yes, everyone was on that side of the counter. Or everyone was on the business ownership side of the counter, not the customer side.
I'll objection as to that speculative answer, Judge. I don't know what the business owner side is and whether or not there's a side for business ownership.
Well, I'll ask him to clarify. Why would you say that? Do you have personal knowledge? What would be the business side?
One side of the counter is where the customers stand and place their orders. The other side of the counter is where the person that gives them their order has access behind the glass.
I understand, but that doesn't necessarily mean ownership. But okay, I understand what he's saying, Judge.
Now, when you entered that room, were they all behind the counter, or did you ask everybody to stand up and come behind the counter?
Everybody was everyone was already on the other side of the counter as we entered inside of the room.
And did you see any ladders or any type of work being done?
No, I did not. There was no ladders. All the tools that were found were in another part of the location that that was basically empty.
When did you get the notice, if you can recall, from the building and safety?
If I can refresh my memory from reading this.
No, that's okay. I'll move on. I have nothing further, Your Honor.
Ultimately, officer, you did see tools in that property. Is that correct?
Yes.
All right. I have no other questions.
The people would rest, Your Honor.
Your Honor, at this point, I'd ask the court to dismiss this matter. I'm moving for directed verdict based off the testimony of Officer Talbert. He's indicated that he did not have any reason to believe that Mr. Maddie was on the lookout for the sale of marijuana. He did not have any documents or records to show that he had ownership of that facility. He did not indicate that he sold any marijuana or that he possessed any marijuana, and that he did admit it was merely present in the facility. He further indicated that Mr. Maddie admitted to him that he was demanding some of his tools back, and that he was there as an electrician, and that he was in a white utility van that looked like the contractor type van. Based off of the totality, the testimony, and in the light, well, Judge, you can do this beyond a reasonable doubt standard in a directed verdict, that the people have not met their burden at this point to say that Mr. Maddie is guilty of operating a marijuana facility.
Before we go further, Ms. Cole, and you respond, would the attorneys object if I asked just a couple of questions?
The people would not object.
Mr. Macklin?
No objection.
All right. Corporal Talbot, how many people were in there when you walked in?
5 total.
5 totals. You arrested them all, correct?
4 were issued tickets. 1 was released with no contact.
The person that was released, why was that person released?
I think that person must have tried to enter the building after we had already gained entry.
So the person wasn't there when you got there, is what you're saying. So that's the only person that you released?
Yes.
Okay. The 4 that you did arrest, were any of them doing anything different? Did you have any drugs on anyone?
No.
You find drugs in the building?
Yes.
Okay. And now you said that the 4 that were arrested all were charged with the same thing?
Yes, they were.
Did they all have drugs on them?
No, they did not.
Okay. So how would you make a determination if somebody was there to buy and somebody was there selling? So you just said everybody here must be selling?
Yes.
Based on what?
Based on the fact that nobody admitted to being a customer.
So they have a right not to talk, right? Everyone. So
Correct.
if somebody doesn't tell you what you want them to hear, then you automatically charge them with the charge of selling because no one told you that they were a customer?
No, sir. Like I explained prior, everybody was on the other side of the counter.
Yeah, I understand that. So you saying the position alone is the reason to charge a person with selling, correct?
Yes,
Okay, so somebody couldn't just be there talking to someone that they know.
they could
You've been to
be.
drug houses before, right, sir?
Yes, I have.
And when you go into a drug house, often there's many people there. Some are sometimes playing music or video games or other things, right?
Yes.
And okay, no, I've heard enough. So, all right. Any other thing that any other attorneys want to say?
The judge.
Just briefly, Your Honor, I think that one of the things that Attorney Macklin indicated that they weren't on the lookout for Mr. Maddie. I don't believe that there was any testimony at all that they were on the lookout for Mr. Maddie at all. And I think that it was clear that the front where there were customers, we're talking about in the back where they actual packaged marijuana or the loose marijuana.
I didn't hear him say there was customers up front or any other room.
No, he said that's where in the front they went to another room. There was nobody in front, as I recall the testimony, but they went. So it's not like they were in the front playing cards or something, but that everybody was in. People in the back were people that were with the loose marijuana and the cash and and the gun. Well, we didn't. In the back area, they weren't in an area where they maybe were just playing around or visiting. So it showed some control or some.
I disagree with that. There is something that's called mere presence. I haven't heard anything that there was any identifiable act to suggest that Mr. Mack was selling or a participant. I heard something about mere presence. There was no drugs found on him. There's nothing that showed that he was doing anything to sell drugs, but it says he was in that location. There is such a thing called mere presence. I don't see any witnesses saying they've seen him actively doing anything out of that place before. They came in, they didn't know him, they didn't know anybody. Because he's standing in a particular location. Counsel, we've seen officers do raids on drug houses, and some people are playing video games or doing things like that. Just because a person's there that is not sufficient evidence to show that the person is active in the sale of drugs. And in this particular case, just the requesting of his tools could possibly indicate why he was there. Where he's standing when the police come in is not determinative of what he was doing and his reason for being present there. He said he wanted his tools. He was doing electrical work there. And by and behold, there's tools that he is requesting and asking for as his tools. I certainly have not heard anything that would suggest that the police officers were in a position to identify who was there selling drugs simply by where they were standing. And I find that I do have to find not guilty in this case because I have not heard anything, again, that would go beyond mere presence.
Okay. Thank you.
I do have to.
Thank you very much, Your Honor.
Thank you.
Your Honor, is there an order that you need to wait for, or is the case?
Madam Clerk, do we have any orders that I can just click and check the box for not guilty by bench trial?
No.
If you want to email me something, I could certainly sign it with prejudice.
Attorney Macklin, if you have an order that you want to send us, I can sign off on it. Attorney Cole, you can sign it if you choose to. It's not necessary as long as I sign it and find that I've heard a strong case for mere presence, but that I have not heard anything that would suggest that any identifiable person there was, and he's also given a reason for being there if he's doing some type of electrical work and and his tools are there. So even if he was doing electrical work and he was selling as well, I don't have the evidence with regard to the sale. I only have evidence that he is present and he's given a valid reason for being there. But I don't have anything to suggest anything more.
Thank you.
Okay. All right, Your Honor. Have a great day, you and your staff.
You as well, sir.
Thank you.
Attorney Barrett, I'm trying to send her a chat and she's.
For which person?
Attorney Barrett.
No, I'm saying for which case were you trying to send her a chat for?
Mozamb.
His case got adjourned to July the 11th. He's gonna try to take the driver training course.
Oh, okay. Thank you.
No problem.
So are you done with me?
I believe so.
Thank you.
Have a great day.
Thank you.
And Judge, we're writing when the court is on a matter scheduled for trial.
Okay. Officer Reeves, the case was adjourned to July 11th, but I believe it's just gonna be set for like a pre-trial because he's supposed to be taking a driver's training course.
Okay, I came out of the break room because I wasn't advised, so I wanted to check. But I'm good with that. You said
I was coming to get you. They started trial and then just went from there.
okay, no
But
problem.
yeah.
Can I get that date one more time?
July the 11th.
July the 11th. Okay, thank you.
No problem. Have a good one.
You as well.
And we're ready on
what?
that case.
This case. Michelle McAdoo.
Yes.
All right. Where do we have the person on screen? Michelle McAdoo. State your full name, please.
Michelle Marie McAdoo.
All right, Ms. McAdoo. You have case number, actually you have 4 case charges. Count 1, or strike that, case number V128752222. You're charged with dogs at large, obviously not restrained in any way. Ticket V128753322. Nuisance. Okay, let's see. V128400022. No dog license. And lastly, V128751. Failed to vaccinate dog for rabies or produce proof of vaccination against rabies. Those are the 4 charges. And attorneys.
Yes, good afternoon. Sydney Rogers for the people, P82072.
And good morning, Your Honor. Herman Griffin for the defendant, P77169.
And how are we going to proceed on this matter today?
This matter is set for trial. There's an offer on this matter. It will be the dog at large and nuisance matter as charged with the dismissal of the balance. Investigator Green is checked in and has been promptly on Zoom. If the trial is going today, which I believe defense is requesting the trial, the people are asking for a brief adjournment as it's just been made aware to my office that there is a complaining witness, or civilian on this matter. It's somewhat of a complicated matter that I believe needs further investigation and potentially, if the adjournment is granted, for the defendant to get court-appointed counsel.
Okay. All right.
Your Honor,
go ahead, counsel.
Yeah, the one thing I want to ask, I just want to ask Ms. Rogers, are we not dismissing the 2 outright today, even if we don't have the trial, the vaccination and the dog license?
I plan on dismissing them. Typically, it's easier to keep them all together. I'll leave that up to the court.
No,
because I have seen documentation for them, so it's not contingent, it's for valid docs.
Okay, no, we'll just keep it all together because if there is something, if there's some valid vaccinations or documents or something of that nature, and it's not presented today, I don't have a basis for dismissing them today. So
we presented it today, Your Honor.
Oh, you presented it.
Yes, she has the vaccination, she has the license. I sent those to Attorney Rogers, and then
okay. And where were they dated?
The very next day, I believe, Your Honor.
Well, then they don't have to dismiss it because on that day, the person was not in compliance. Generally, what happens is when they're going to make a deal and they're going to dismiss a case, then they will go ahead and accept that because they have come into compliance. But if it's going to be a trial, on the date of trial, the date of the offense, they were not compliant, so they don't have to dismiss it.
Understood.
And that's one of the things they do when they want to make somebody an offer and make it easier for everyone. And they'll say,
we'll just dismiss it as if it was they were compliant on that day. But there's no requirement that they dismiss something because the documents have been presented now. If there's gonna be trials on other issues, and that might be something that they want to make part of their argument. So, and they can do that.
So from defense's perspective, Your Honor, we're asking for dismissal without prejudice. The complaining witness is not here. In terms of for the allegations of several allegations. So from our perspective, the people aren't able to move forward, and we would, like I said, be against the adjournment because today is set for trial. There may have been, well, we know that there was at least an arraignment. I don't know if there was also a pretrial in this matter, but for the allegations, the officer doesn't have, from our perspective, personal knowledge. And so the complaining witness is necessary for the case. And so that's why we would ask the court for dismissal. If the dismissal is not granted.
Well, I would consider this, counsel, from your perspective. If I dismiss it today, they can reissue it. I think you want to go for something that'd be a bit more permanent resolution. Because if I dismiss it today, they could turn around and reissue it, and all that does is prolong the case for your client. So
that's okay, Your Honor, because we believe that we presented some information to the prosecutor. And so they may reissue, but they may not. And like I said, so we're okay even if it's dismissed today and possibly reissued.
Okay. All right. Well, let's see. If I were to dismiss it today, because would all charges be dismissed, or is it only some that would be dismissed for failure of someone to appear?
Well, we believe all charges, Judge, because if the prosecutor is okay with dismissing the 2 charges that we had spoke on, then the balance of the 2 charges will be dismissed for the complaining witness failure to appear. So,
Ms. Rogers, your response?
Yes, so the 2 document charges would not be appropriate to dismiss for failure of the civilian victim for not appearing, but it wasn't due to the civilian victim's fault that he did not appear. I was just made aware that there was a victim this morning. I got the report this morning. He was not noticed yet. That's why I'm asking for additional time to give him notice and a subpoena regarding this matter. And it would just make more sense to keep these all together instead of keeping the document charges alive today. This seemed to be a fairly complicated matter with a lot of moving parts, and that's why I'm asking for a brief adjournment on this matter.
Okay, you said the complaining witness was not notified?
No, I just got the bite report this morning from Investigator Green.
All right, so you requested the subpoenas to go out and it did not go out? Is that what you're saying?
So I subpoenaed Investigator Green, but I was not aware of the civilian, so I did not subpoena the civilian.
All right.
and if we could respond, Your Honor, briefly.
Yes, yes.
Your Honor, we understand that the civilian person was not given the subpoena. However, we don't believe that my client should basically be held responsible for the people not requesting a subpoena for the civilian. And so again, that's why we would understand if there's a dismissal, even without prejudice, if they want to reissue, they fully can. However, again, they may not. And so we would still stand by our position of a dismissal.
Well, who is the civilian witness, counsel?
Which counsel are you speaking to, Your Honor?
Ms. Rogers, that was not subpoenaed.
It is Mr. Kincaid. I have a first name.
Who is it? Who is it to the case?
Oh, he is the neighbor of the defendant and the person that was involved. This is a dog bite case. The person that was involved in the dog.
No, I'm not dismissing it because he has a right to be here because he was not subpoenaed. It's not his fault. And I'm not going to take a civilian and say, well, they messed up and you got bit, but we're not going to go forward with your case. So, and I'm not going to bifurcate it. So they're asking for a short time to get the civilian witnesses, which they have a right to be here. And certainly because something happened, and unfortunately, many of these cases, the tickets are not detailed enough that the prosecutor would necessarily know certain things until later. And I'm not gonna let someone who was bitten, and I certainly don't know how badly it was, and I'm not gonna bifurcate the case, which could cause problems with evidence. So no, they're going to get a short adjournment, and then we can make a determination how it can be worked out, if it's going to be worked out. But the civilian has a right to be heard on that case.
Your Honor, is it possible then, instead of a trial, to have maybe the final pretrial with the complaining witness present, so they can possibly resolve the matter without having to, I guess, subpoena the officer again?
I don't have a problem with that. We have, that's something you and Ms. Rogers can work out and make a determination. If you want to have a pretrial and there might be some settlement discussion, we certainly can do that. But, the victim has a right to be notified, so.
Right. So I leave it to Ms. Rogers
discussion.
if she wants to. Otherwise, we can just set it for trial again. And I would ask for appointed counsel for the defendant.
Attorney Griffin, I have no problem having my witnesses at a final pretrial, but I think it'll be more efficient just to set it for trial so we don't have to do this twice.
Okay, then that's fine. And then I would ask for appointed counsel, Judge.
So even if we set it for trial, you still can have that discussion about some type of resolution. That's not gonna preclude.
Okay.
So, Madam Clerk, Attorney Griffin, would you go back into the room with Ms. McAdoo and
Yes.
And get all of the information that we're going to need to give to the people who would sign counsel for her?
Yes, Your Honor. I just want to inquire from Madam Clerk the information that she would require.
I need her name, address, email address, and phone number. And the trial date is going to be July the 13th because they need time to appoint a counsel, as well as whatever Attorney Rogers need to do on her end to make sure the civilian witness is available as well.
Ms. McAdoo.
Yes,
Ms. McAdoo?
Your Honor. Yes, Your Honor.
I want you to understand what's going on. This actually is something that will work, could work for your benefit. What's going to happen is we're going to put your name and send it to the organization that works with the courts, and they will assign an attorney to you. So you won't meet the attorney on the day of trial. You'll have an opportunity to talk to them in advance, and you can discuss strategies of how you want to go forward. Unfortunately, when we're doing things like this, there's a house counsel that will meet you today and potentially have a trial with you today. I don't think that's necessarily fair to you either. So attorney will contact you in advance, and you can go over everything, and you can develop your strategy, and you can and see what works out best for all parties. So,
Your Honor.
Yes.
This is the fourth time I've come to court about this where nothing has happened.
Well, ma'am, I certainly apologize for that. I don't think I was a part of those things, and I'm not sure what has happened in the past because I don't have the history in front of me. I only have the tickets in front of me. And certainly, we're not going to, the next time you come, it certainly will be resolved because we're going to set a trial date, and either it's going to be worked out on that day or we're going to have the trial date, but it's going to be resolved on that date. So I apologize for any past inconvenience. So,
Thank you, Your Honor.
And Judge, before defense goes in the breakout room, I am not available on July 13th. I'll be in a jury trial, but I am available July 12th.
Okay, that's fine.
Thank you.
Ms. McAdoo, McAdoo, I apologize, ma'am. I certainly always try to, or I endeavor to pronounce people's names correctly, and I apologize if I've butchered yours as I have today. July 12th, you don't have any conflicts, do you?
No, I don't, Your Honor.
Okay, that's going to be the date of trial, and this is going to be, well, let me ask this, Ms. McAdoo, and counsel can assist you, the attorneys that's here today. Do you know the difference between a jury trial and a bench trial?
Yes, I do, Your Honor.
Okay, do you You have a right to have a jury trial. And I'm asking, is that something that you want to do? If you want to talk to attorneys today and they can explain to you the difference. I know the main difference is you would have a jury, it would be 6 people from the community that would sit and they would have to come to a decision, a unanimous decision that if they want to find you guilty, they all would have to agree to that. The bad thing about it is it generally takes at least a full day and not what we would hear with a bench trial. But I don't say this to influence you, ma'am. I just want to let you know that you do have a right to have a jury trial. And if you want to have a bench trial, I just want to have that on the record, that you understand the difference, and that is whatever the decision is, that's your decision to make. Certainly, I don't have a ball, anything in this. It does not matter to me if you want a jury trial or a bench trial. It's certainly your decision to make, and I don't have anything to say on it.
Thank you, Your Honor.
So do you know at this time if you want a bench trial or a jury trial?
I'd like to discuss that further with the attorney.
Okay, very well. Attorney Griffin, you were speaking to her, is that correct, earlier?
Yes, Your
Okay.
Honor. I'll go back in the breakout room with her and I'll gather the other information that the court needs.
What room were you in, Ms. McAdowell? If you touch your screen, it'll show that you could go back into that breakout room and the attorney will meet you there so you can have a private conversation.
Thank you, Your Honor.
I'll go right now. Thank you, Judge.
Mm-hmm.
Are we ready on Moultrie case?
What's on Moultrie now? What are we doing on?
He said we're gonna do the no contest plea due to lack of memory.
Okay. All right. While they're in the breakout room, Ms. McAdoo, you've got to go back into the room for the attorney to talk to you there. If you touch your screen, it should show that you could go back into the breakout room.
It's not showing me that, Your Honor.
Okay. Maybe we have to send you back in.
I'll just put in another call.
Senator One. Senator One, because that's where attorney was. But now.
He was down to 7.
Oh, he was 7.
I just put in 5. Supposed to go to 5.
At first I saw him in 1, so now they're both in 5. Okay, great.
Madam Clerk, I kind of lost my client. I'm which breakout room?
Go in 5.
Go in 5.
Okay. You said 25 or 5?
5.
Okay, thank you.
Ms. Baird, what happened to Moultrie? That was going to be pleaded to 1 charge of failed to display, and then
Everything else was dismissed.
But so what? Why did we? What happened on that now?
He said he couldn't recall.
Oh, he could not recall. That's the I cannot recall. Right. All right. So you said he's going to do a no contest.
Yeah, for lack of memory.
Right. Very well. Okay. All right, let's see. Let's get him. Where is he now? Would you go into 4 and tell him to come out? Because when they
He's right there. Remember
he's in the courtroom. That's right. All right, come back up to the table, sir. So, Mr. Moultrie, it is back on the record on SP 9425113, Mr. Javon Moultrie. With the companion cases of SP 9425112 and SP 9425111. And let's see, I don't think the state charge is in that. I just read. Let's see. Let's see here's the others. This is 400. Strike that 19400009 where Mr. Moultrie had 3 charges under 1 ticket number. Count 1 was no operator's permit. Count 2 was motor vehicle, unregistered motor vehicle, and count 3 is no insurance. All right, we called these cases with Mr. Moultrie, and he indicated that he had lack of memory and could not recall if in fact the charge that was he was going to plead to and the other 4 or 5 were going to be dismissed. So Mr. Moultrie, you're back before the court now. I understand through counsel that you want to have a nolo contendere plea. All right, just so you understand, a nolo contendere is with, well, Latin basically that says you are pleading no contest. Because of lack of memory, you're not, there are some allegations out there and you're saying that I'm not contesting them and I will accept the plea of guilty on that matter. Is that what we're doing, sir?
Yes.
You understand that even though you're pleading no contest and you're not contesting the allegations, it has the full effect of a plea. You understand that?
Yes.
It is for cases like this where you said, I can't remember something, but I know it occurred. There's something out there and I'm not contesting it. And that's what we're doing, sir. Is that correct? All right, Mr. Moultrie, I swore you earlier to tell the truth, and you accepted that you would swear and everything you said is true. So on the charge on ticket number 194000009, on the date of May the 2nd, 2019, the officer wrote a ticket that said you were driving a motor vehicle on Finkel and Evergreen, and that when they stopped you, you did not have a valid driver's license. Do you remember any of that you were driving on that date, or anything that you were stopped by the police? Okay.
Can I speak up, please, Your Honor? The defendant.
Sir,
needs to
when you
speak
said
up.
you said I don't remember anything, you have to speak loud enough that your sound travels to that little star microphone there. So you have to speak up.
I don't remember anything.
Okay. All right. On that date, sir, let me ask this. Do you remember this? Did you have a 2000 Cadillac that was tan in color?
I just don't remember.
You don't remember what cars you had? Have you had any type of traumatic injury to a brain injury or anything like that?
Played football.
So you're saying CT, what is CT? Well, as a result of hitting your head or being hit in the head, that you sometimes have memory loss, is that what you're saying?
Yes.
Okay. All right. But you're not contesting, you don't even remember what kind of cars you had.
I had a lot.
You had a lot. Okay. All right. Well, the allegation from the officer, sir, is that you were driving that area. Does that area sound familiar to you, that you would be driving in that area, Finkel and Evergreen?
Yeah, my dad.
Your dad lived over there? Okay. All right. And this would have been about 10 p.m. Yeah, it says 10 p.m. So that would not be unusual for you to be driving over that area at that time. No, I'm just saying unusual. I'm just saying your dad lived in that area. You would be there sometimes.
Sometimes.
Okay. All right. All right. Sir, if you're not contesting these charges, I'm a little troubled that you don't remember anything, including the type of car you were driving. But you're not contesting that. So I will accept that because in the long run, you do get the deal from all these other dismissals. You're getting 5 charges dismissed by pleading to 1. And that charge of no operator's permit will be reduced to fail to display. Your fine is going to be $225. Can you pay that right away, or do you need time?
I'll pay it as soon as I walk in.
Okay. Yeah, I need you to wait a little bit more. Madam Clerk, how quickly could you get this in the system? All right. She says she's going to put it in the system right now. Normally it takes a day or so to get the system, but she's going to do it. So you just give us 15 minutes or so. She could get it in the system, because if you go down there and they punch it up and they're not going to see, they're going to see the original charges. We're going to make sure that the other ones is going to show it's dismissed and you're only pleading to the 1. So just make sure you give it at least 15 minutes or so. Okay.
All right, thank you.
All right. You're all set, sir. Good luck to you. Stay safe.
All right, you have a blessed day.
So are you seeing a doctor at all, sir? for any type of injury? And see,
Well, I do, see